We're also ready on
I have.
Harvey Edwards and Jorge's.
City of Lansing versus Cody Swankara. These are file numbers 21L265693133.
Captain Gonzaga, City Runner.
Under Jeffrey Kaplan, P 74943, on behalf of the defendant who's appearing by Zoom.
Mr. Swankara.
Hello.
Okay, Mrs. Swankara, what happened to you this morning?
My phone got locked in the car, and it's not my car, and they were gone to work, and I can't get my phone out until they get back from work. And I walked down to the library, and I got out at 11, and they told me to get back on at 1:15. So
Okay, this was a improper low tow. And then a failure to display office license. How are we proceeding on this?
Your Honor, my client would like an adjournment. He is still trying to get his license reinstated. I'm assuming that somebody drove him, his friend drove him this morning.
no, I walked.
It's like his friend's car.
He said he walked.
Well, but it's his phone and his keys were in his friend's car. I just wanted
Oh,
to
yeah,
clear.
he did make that clear. It wasn't his car, so it was walking someone's car. Correct.
So you'd like an adjournment so that you can have time to continue to work on getting his license reinstated.
What is it gonna take for him to get his license reinstated?
What was that?
Oh, I didn't get that far. At what stage are you in getting your license reinstated, Mr. Swankara?
What was that now? You
What
broke up.
stage are you at in getting your license
I'm
reinstated?
just waiting on getting my birth certificate in the mail, and then I can go get it.
You still working with Glad Tidings to get that done?
Yep. He's supposed to be taking me as soon as I get my mail, as soon as I get that in the mail. I just haven't got it yet. I thought I'd have it by now.
Give me the date. April 8th at 10:30.
Okay, thank you.
Any additional matters for the record?
After the defense, Your Honor.
Okay, you're all set, Mrs. Swankara.
Thank you. Sorry.
No problem. On the record in the matter of the City of Lansing versus Harvey Edwards, 23-02597. Appearance, please.
Captain Gonzaga for the city.
Your Honor, Jeffrey Kaplan, P 74943, on behalf of the defendant who is appearing by Zoom.
Okay, Mr. Edwards has a trespass. How are we proceeding on this?
Your Honor, I've spoken to my client. The prosecutor has made an offer to reduce this to a civil infraction for breach of peace. That was a $150 fine. I explained that to my client, and he would like to avail himself of that offer, Your Honor.
Is that correct, Mr. Edwards?
Oh,
I can hear you repeat that. Okay. I need you to stand and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
yes,
Okay, you understand that you have the right to proceed to trial and a jury trial in this matter?
yes,
You can put your hand down. You understand that you have the right to require the city prove the charge of trespass beyond a reasonable doubt, and you can remain silent at that trial and not have silence be used against you. And you have the right to question any of the witnesses that they call to testify against you, and the right to subpoena witnesses that will testify on your behalf.
yes,
Yeah, you want to give up all of those rights?
yes,
Okay, anyone threatening you to get you to plead guilty to trespass?
yeah,
Who's threatening you? Who's threatening you, sir?
nobody threatened me.
Okay, my question was, is anyone threatening you to get you to plead guilty to trespass?
Oh, no,
promises being made to you if you plead guilty?
Yes.
Are you employed?
No.
How do you support yourself? How do you make a living, sir?
I work now and now. I work time to time. It's just I'm unemployed right now.
As to the trespassing, how do you plead?
Guilty.
Factual basis, please.
I'm looking for that, Your Honor. Not seeing.
Okay, sir, on or about August 14th, 2023, at approximately 9:27 in the morning, were you at the area at East Lenawee near South Grand?
Yeah.
What is located there?
My sister.
At your sister's house?
Yeah.
Okay, and were you asked to leave?
No.
You were not asked to leave?
No.
Okay, so how was it that you ended up with a citation? You were there visiting your sister?
Yes.
Okay, and your sister you were allowed to be at that location? There wasn't an order telling you that you weren't allowed to be at that location?
Yeah. It was. Yes. Yes, it was.
Can I clarify briefly, Your Honor? Apparently, there's a
Are
woman.
you questioning? Because you're not gonna clarify by putting statements on the record. He's gotta do the factual basis, and I didn't think you had it.
Right. Well, I can ask if.
Okay, thank you.
Mr. Edwards, there is a woman who lives across the hall from your sister there, correct?
Yeah.
And that's the woman who had complained about you being on her property, correct?
Yeah.
And you were informed by police not to be there anymore, correct?
Yes.
Okay. And you did go back there, correct?
Yes, my sister needed help. Yes.
I'm not following. His sister lives on this lady's property?
They live across the hall from each other. So I guess I should have clarified that as well. Is this an apartment building they live at, Mr. Edwards?
Yes.
Okay. So the neighbor across the street or across the hall ask to have him not be at her property?
Yes.
Okay, and on this date, he was at her property?
Mr. Edwards, is that accurate?
I wasn't at her property. I was at my sister helping her move. My sister don't live there no more.
The police not gonna work there.
Yeah,
Like, they stay across the hall from each other.
I understand that. I understand that.
Your Honor, at this point, I think we should just ask for an adjournment. I don't have this report in our system.
Okay. Okay, I'm gonna set up a final pretrial.
Sorry, Your Honor.
No problem. He's in custody for something else other than this, correct?
That I would have to take a look. I'm sorry, what date was it?
I'm sorry?
What date was it? Rescheduling this one?
I haven't rescheduled it yet.
Oh, I'm sorry.
March 25th at 8:15. March 25th at 8:15. It's a final pre-trial, so you need to appear in person. I'm sorry? He's got plenty of, and he's being held on that. Okay, well. Get him ready over for that then. Do you have any questions today, Mr. Edwards?
No.
For the record, the witnesses that are not officers need to appear. You're all set, Mr. Edwards.
Yeah,
Okay, we have Dante Robinson. I'm sorry? Yeah, are we ready on his matter?
We're ready.
On the record, in the matter of the people of the city of Lansing versus Dante Dion Robinson, 25-00175, appearance, please.
Catherine Nichols Linedecker for the city, Your Honor.
Jacob Riley on behalf of Mr. Robinson.
well, God.
Mr. Robinson has a failure to stop after property damage accident that's set for pretrial. How are we proceeding on this?
Mr. Robinson is prepared to enter a plea as charged.
Is that correct, Mr. Robinson?
I can't hear.
He said you're gonna plead to the original charge.
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
You can put your hand down. Okay, you have the right in this matter to proceed to a jury trial and require that the prosecutor, which is the city attorney's office, prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to have witnesses subpoenaed to testify on your behalf. You have the right to question or cross-examine any of the city's witnesses, and the right to waive your silence and testify on your own behalf. Those are all rights that you want to give up today.
Yes, ma'am.
Anyone threatening you to get you to give these rights up and plead guilty to the failure to stop after property damage accident?
No, ma'am.
As to the original charge, how do you plead?
Guilty.
Actual basis, please.
Thank you, Your Honor. Mr. Robinson, on May 23rd of 2024, were you operating a vehicle in the area of Comfort Street in Lansing?
That's correct.
That's in the city of Lansing, in the state of Michigan.
Yes.
It's true that you had an accident, essentially that you had a single car accident at that time?
Yes, sir.
True that you crashed into a tree?
Yes.
This caused some damage to the vehicle you were driving?
Yep.
Is it true
That's
that
correct.
you left the scene of that accident on foot before you had any contact with police or other?
That is correct.
Thank you.
Any other questions?
Nothing further.
The court satisfied with the factual basis. I'll accept your plea. I find it to be freely, voluntarily, and intelligently made. It's $100. You're all set.
I ain't hear you.
Excuse me?
Well, we would ask for a PSI as it relates to the restitution consent.
There's restitution.
I believe the vehicle he was operating was not his own.
I don't know how that's gonna be sought on the restitution on this case. Let me see here. The vehicle he was driving was not his. Did he cause damage to another vehicle?
I think the vehicle is registered to his mother. He was using it as his vehicle, but it was not registered to his mother.
And so his mom is seeking restitution, is what you're saying?
No, she's not.
I'm unclear, but I would like the opportunity to ensure that that is accurate.
I'm not sending for a PSI for the maximum sentence is 90 days or $100 on a property damage accident, and he's in custody. So if there needs to be a restitution hearing, I can set it for a restitution hearing. I don't need to set it for a sentencing for that. So that's, yeah, that's a sentence. If there needs to be a hearing, then you can subpoena a witness and she can provide evidence that she did not get her car paid for through no fault insurance, that's another, I really don't even know how she can seek restitution through this, but that's a whole nother issue. If she was the owner of the vehicle and gave him permission to drive the vehicle. Roger. So I don't, so nonetheless, you can notify us later if you need a restitution hearing.
Thank
We
you,
don't-
Honor.
We don't need to do it today.
Absolutely, I just wanted that opportunity.
And then we'll have him ready for that purpose. And then I intend to have a remittal form submitted to Department of Corrections for this payment. I don't know how long he's in MDOC, but you're all set for today, Mr. Robinson. What matter is Mr. Hayes on? He's here for Zuniga. We're having a hearing on that.
Kaplan's.
My understanding is there's another violation.
Correct, but are we having a hearing on the one that was subpoenaed for hearing today? Because we have a witness here.
Can,
He's contesting, is what you're saying?
correct.
Okay, we can, who's the probation officer? Okay, we want to bring the probation officer up on that one as well. I will run the hearing today because Mr. Hayes is here. And then Hassan is here.
Yes.
He does not have an attorney?
No, he does. Jacob Rowley.
Oh, okay. City of Lansing versus Fadul Hassan, 25L 2913502 and 501.
Hi, Kathy Nicholson, for 60.
Jacob Riley on behalf of Mr. Hassan.
Okay, Mr. Hassan had a pre-trial for failure to display ops and then a no plate explanation hearing. How are we proceeding on these?
Your Honor, it's my understanding that defendant wishes to avail himself of the following offer, and I can approach with the sheet. The failure to reduce to impeding and admission of responsibility to the no plate.
This is civil infractions. That's how you want to proceed, sir? Why, what were you looking at and listening to?
I was listening to him.
You were sidetracked?
No, I wasn't listening to her because I'm just waiting to contest what you guys said.
You was, okay, she said that you wanted to accept responsibility to 2 civil infractions, that she will amend the failure to display operator's license, which is the misdemeanor, to impeding traffic, that's a civil infraction, 0 points, and it's a fine. And that you will accept responsibility to the no plate violation. Is that what you want to do?
Yeah.
You sure? He's not sure, so he needs to speak to his attorney some more. Do you have any other matters ready to go right now, Mr. Raleigh?
I have Benjamin Smith on Zoom.
Benjamin Smith? Okay. Mr. Smith, insert your video, please. City of Lansing versus Benjamin Smith, 25L 29227442 and 741. Appearance, please.
Catherine Nicholson, for the city, Your Honor.
Jacob Riley on behalf of Mr. Smith.
Mr. Smith has a driving and registered vehicle and a no proof of insurance. Are we proceeding on these?
Your Honor, I believe that he has provided perfected documents, if I may just confirm that. Yes, we would be moving forward with the dismissal for both of these charges. Thank you.
The motion to dismiss is granted. You're all set, sir.
Thank you.
You're welcome. You have another one, Mr. Rowley?
We have Jameric Cates also on Zoom, Judge.
City of Lansing versus Jamera Cates, 25-00325, 25L29, 23382 and 83. Appearance, please.
Catherine Nichols, line here for the city, Your Honor.
Jacob Riley on behalf of Ms. Cates.
Okay, Ms. Cates has 3 files: the driving while license suspended and unregistered, and no insurance. How are we proceeding?
Your Honor, it's my understanding that this case has a valid license now, so we would be dismissing the DWLS. It's my understanding that the defense attorney is seeking adjournment as to the drove unregistered and no insurance.
Yes, Your Honor, Ms. Cates is still working on fixing those 2 issues.
So you're gonna reset the DWLS and she's done what?
We're gonna dismiss the DWLS. She's
Oh.
not perfected, Your Honor, so we'll just be moving forward with adjournment on the remaining 2, 8-2 and 8-3 files.
April 8th at 10:30. April 8th at 10:30. You have any questions for the court today, Ms. Cates?
I do not.
Any additional matters, counsel?
No, Your Honor.
Okay, you're all set, Ms. Cates.
Thank you.
You're welcome. Quan Tatum here? Tatum, that is?
He is on Zoom also.
Yes, I'm here.
Okay, Mr. Tatum, I do have a file number here, 22-03189. And there's a request and summons for probation violation, and the allegations are that you violated the terms and conditions of your probation per order or amended order from November 18, 2024. It says that you failed to submit to random urinalysis testing on January 5th, January 17th, January 22nd, February 1st, February 10th, and February 22nd. It also states that you failed to complete the victim impact panel as directed. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If you're found to be in violation of your probation status, your probation can be revoked. You can be sentenced to serve jail time. You also can have your probation status extended. It's by nature extended by the fact that this was filed before the end of your probation date, which was supposed to be next week. Do you understand that?
Yes.
Is that okay? Did you want an attorney to represent you?
Yeah.
The court will enter a plea of not guilty on your behalf, and this will be set for a hearing. You must appear in person for your hearing.
Okay.
March 25th at 1:15. At 1:15.
Okay.
You have any questions today?
No.
Okay, you hang tight and we'll get you in a private meeting room with the public defender in just a moment. They need to get some information from you.
Okay.
Okay. Kyla Williams. Remove Dante Robinson.
I'm here.
City of Lansing versus Kyla Williams, 25-00234. Appearance, please.
Catherine Nichols, line here for the city, Your Honor.
Jacob Riley on behalf of Mr. Williams.
Okay, Ms. Williams was scheduled today for a pretrial. This is for open alcohol in public. Is there an offer on this?
Yes, Your Honor. The city has offered to bring this matter at the next setting. If Ms. Williams comes in with current pay stubs and proof of attendance of 4 AA from 14 days, with 2 being in person starting tomorrow, no further bond violations, we would dismiss.
Lieutenant, that AA, 4 AA sessions,
Correct,
2 in person,
correct.
and I didn't hear the ending part, that someone said something.
No bond violations.
Then the city would dismiss.
Yes, and those 4 A's would be in 14 days starting tomorrow.
You said within 14 days, within 14 days?
Correct. Yeah. The 4 A's in 14 days starting tomorrow, 2 of which need to be in person.
And how does your client want to proceed?
And to be frank, my client has some issues with that suggestion. We're agreeing to that arrangement, frankly.
You said your client is struggling with that.
I mean, I don't think she necessarily feels that she needs the AA meetings, if that's necessary in her situation.
Got it. Okay. Well, she's got to accept the offer if she doesn't want to. It's up to her. And she has options. She can accept the offer. She could not accept the offer and do nothing. We proceed to trial. She could plead guilty to the charge, or we could go to trial.
We know, Your Honor, that the offer was extended based on her employment. And if the charge moved forward, then perhaps her employment would be no longer. But of course, if she wishes not to avail herself of that offer, then that's her own choice.
But I think it's a reasonable offer. I mean, if the city's taken into consideration her employment status, which I don't know what that is because it said unemployed when she was arraigned. What's her employment status?
I believe she's not currently employed.
I was under the impression that she may be working or has worked in adult foster care.
Never.
Okay. Well, nonetheless, if your client doesn't believe that the attending AA is meaningful for her, she doesn't need to attend, and that's just an offer to resolve this outside of moving forward with the trial. It's an open alcohol in public. You can advise her what the ramifications of that is.
Yes, sir.
So we can set this for a second free trial if you want more time to talk to her.
That would be our request.
April 8th at 10:30.
Okay.
Any additional matters for the record?
Nothing from the city, Your Honor.
No, Your Honor.
Do you have any questions for the court today, ma'am?
I don't.
Okay, you're all set.
Or if I may, I apologize. I just wanted to correct the record. It's the healthcare employment rather than adult foster care employment.
Oh,
But
okay,
nonetheless,
sounds
that
good.
doesn't.
Right, and I'm just looking at the citation, because obviously this doesn't, I don't have a affidavit of probable cause. It said open tequila in the central console, so it wasn't even charged as open alcohol in a vehicle. It's charged open alcohol in public. You can advise your client of the difference on those.
Yes.
You're all
I'm
set,
still
Ms.
here.
Williams.
Okay.
Thank you.
Okay.
Cody Wade is
He's
present.
here.
He has an attorney? No? No? Appointed counsel was requested. It said he requested court appointed counsel. Was it denied?
I didn't get an email that it was denied.
Well, Mr. Rowley, if you can log in and meet with, who's I just arranged it, Tatum?
Yes.
If you can meet with Mr. Tatum, he requested an attorney for his probation violation, and then if you can let me know what's going on with Mr. Wade as it relates to whether or not he has counsel, because he requested it. In the interim, we're gonna do this hearing. Yeah, Zuniga, I called the probation officer if I saw her up here. Yeah, she's here.
I was just gonna check the hallway for the 1:30s, but
She can check always for the 1:30s. And Rhonda will do that. Okay, on the record in the matter of the city of Lansing versus George Zuniga Jr. 24-01453.
Thank you, Your Honor. I think the first name is pronounced Jorge, correct?
Your Honor, I apologize, but for clarification, is Mr. Ray going to be reset for a different day?
No,
or
he's
come
gonna
back?
tell me if he has an attorney, because he requested an attorney.
Okay, thank you.
And they never told us if he was denied.
Okay, thank you.
Okay, this was the date set for a probation violation. I also have a new violation that you need to be arraigned on. That in custody. But it doesn't say it on here. I thought I arraigned him on both too, but let's see here.
Your Honor, may I approach your staff? I'm hoping they're getting something printed quickly.
I saw him on the 25th. Unless I'm missing something, I don't see anyone in here since I arraigned him. Well, I don't know why it's set for a arraign. Set it. He's already been arraigned on the 2 violations in my file because I arraigned him after I signed it.
I only see one file. I only have one.
I have one stated for February 3rd. Refrain from alcohol per JSG Scram confirmed tamper alcohol detected began at 11:46 p.m. on 1/27 and ended at 6:13 on February 1st, 2025. And then I have another requested summons that was dated February 18th. It says, failed to submit to tether per JSG monitoring confirmed tamper 10:12 a.m. at 2/11/2025 and ended at 12:22 a.m. at 2/13 2025. So he was arraigned already on both these. You need to approach about something.
Yes, I need to get something printed.
Oh, okay.
I'm so sorry. May I run?
Fine.
to the office and do that? I apologize.
Well, you need something printed from.
Just the violation packets for, I was
Oh,
unaware
okay.
that this was gonna be contested. I'm still ready to proceed. Of course, we have our witness, but I've been trying to get that communication from the public defender's office.
Isn't that what you guys sent in the email?
Yeah. She can print it.
It's just probation packet, so I will expect.
We have some civil people here. That's going.
Yes.
What do we got?
I feel 40 now.
Shady.
November 25th, November 26th.
Who's here
Mr.
for,
Blanchard.
who's here for TD Bank? Did Mr. Raleigh meet with Mr. Tatum?
At the CPM? Sorry, I know. Is it? Is the request in front of that from 215, that the one that we wanted on? Yeah, she.
14 to 2 Peters.
2:30.
Is Catherine Colby Lycos here? Mr. Smith, this was set for a review, but I don't see the other party. Did you all resolve this?
No, we received none of the documentation out under the subpoena, Your Honor.
How do you want to proceed?
Well, I'd like to proceed in two ways. I'm gonna reach out to her again. We'd sent her a letter after the last hearing reminding her what to send to my office. We'll file a motion to show cause with 9-day mailing, but I'm also gonna reach out to her directly to remind her that she was supposed to appear and send documents. And if I can get those documents before that show cause date, we'll cancel.
Okay, I'll note that that's how we'll proceed. You're all set for today.
All right, thank you, Judge.
Thank you. You still need some more time?
I
Oh, you're still coming, okay.
was hopeful that she would also be able to print counsel another as well.
Let's see, Rafaela Trevino, who's here on behalf of TD Bank?
I am, Your Honor, William Saloom from Buckles and Buckles.
Okay, this was a motion for summary disposition. I can put you both in a private meeting room for now to see if you can resolve this. Otherwise, I'll call your case once I'm finished with my criminal docket.
Yes, Your Honor, we can go in a breakout room.
Can you put them in a breakout room, please? Let's see. Is it Mika? You're muted, ma'am.
Hello, yes, Shamika Barney.
Oh, 2:30, okay. Shamika Barney at 2:30. For pre-trial. Johnny Davison, I don't believe is here yet. When Johnny Davison appears, we'll get you in a private meeting room.
Okay, thank you.
So that, and someone will assist you with completing a joint pre-trial statement if he appears, okay?
Okay, thank you.
Not you. What's your name?
Thomas Blanchard.
Blanchard,
It's 2:30.
okay. I thought I seen someone here for Discovery Bank.
Dude, I'm gonna make copies. They won't want print copies.
Yeah.
This one's just slow.
Oh, that's fine. Anyone here on behalf of Discover Bank? Maybe it's too early for that. LVNV funding versus Dominique Davis.
I'm here for plaintiff.
Leslie Honig for the defendant.
Okay, I don't believe that you all do, but did you need to go in a private meeting room to see if you can resolve this? Otherwise, I'll call the case.
I think that'd be
after I
helpful.
finish. Okay, well then let me get you in a private meeting room. You can put them in a private meeting. Thank you. Andrew Trito. Who is that in jail?
That is, looks like Anthony Edwards.
He has an attorney?
He jumped.
That sounds like an officer. It looks like it's an officer's name the way it is on the document. Well, let's get them in the meeting first, and then. Shadi Bayok.
Yes, Your Honor, I'm here. I'm here, Your Honor.
Shiny bio.
Co-compliance for what?
That's where his name is. Amanda Brooks.
Hello?
Okay, we're having a
Can you hear me?
co-compliance as well. I can hear you, thank you. Is Yolanda Brooks here?
No, she has not checked in.
How did we want to proceed on Brooks? Adam? She's failed to appear. I'm sorry?
For the co-compliance?
Yes.
Seeking the hearing date.
Okay, she was served first. Or did you want to find, typically, your office handles those a little differently. Sometimes they will ask for a reset date and a first find the issue. Is that what you want?
Yes, ma'am. Thank you.
And then your office will produce the order. And for me to sign.
Great.
And when Ms. Nash comes out, we'll get you the 30 day. Are you all set, Mr. Bio? No one's appeared.
Okay, thank you. Thank you, Your Honor.
This is Melanie Wanji, is the attorney for Mr. Edwards. I just sent her an email.
Please, wait, what?
Wanji. He said she's Mr. Edwards' attorney.
On the failure to display license? And like, Ms. Wanji doesn't appear on Tuesdays.
Yeah, I don't know. I just see her in our system as the listed attorney.
Okay,
I sent her
well.
an email and.
Let's see if we can get. Let's see if we can get someone in the system today.
Your Honor, can I briefly speak with my client? I just want to make sure we're on the same page about the violation.
That's fine. Okay, well, it looks like, so let me see if they'll let me into on base today. They did not let me in yesterday. Council Quinn and Honig, did you all resolve the matter, or are we ready to proceed?
Can we just get a 30-day adjournment? We do have a resolution and we should be able to get the paperwork in within that time.
Okay.
April 15th at 2.
April 15th at 2 work?
Works for plaintiff.
Just a second. That works for defendant.
Okay, we'll reset for that date. Thank you.
Thank you, Your Honor.
All right, take care.
Same to you. You don't want to let me in office. Mr. Raleigh, maybe you can provide me some understanding. We have someone here, Anthony Edwards.
Edwards.
Are you representing him?
No.
It says, he said that your colleague says that Ms. Wanji is supposed to be representing him on a licensing matter.
guess a matter in a different judge, perhaps.
Yeah, he had public defender on this, I thought, but, he did request it, no, maybe he didn't, it says decline.
Well, he has a circuit court case with this one.
I think he declined an attorney on this.
5/23/24, it indicates he applied for another court appointed attorney.
I seriously. Yeah, it's not marked off declined on here. I don't see where he requested one ever. And I reset it for 60 days for him to clear his license, and then he failed to appear. And then that brings us to this point. Mr. Edwards, did you request an attorney?
No, I did not, ma'am.
Okay. Was there an offer on this? This was already set. It's a failure to display operator's license. He's failed to appear multiple times, but I reset it once to give him the opportunity to clear his license. He's being held on something else. Felony?
I remember I'm considering it's already been adjourned at least once, so we would just go as charged at this point now on consideration for any fair time served.
I might have been, was he remanded to see? She gave him a PR bond. Oh. He doesn't have anything else to do. I don't know why he's in Pennsylvania. What are you being held on, sir?
Probation violation.
Probation violation.
Wait, I'm waiting to go back to, I'm waiting to go to ICAP.
Okay. Well, this is a failure to display valid license that we reset last year for you to get your license cleared, but you never came back to court. And so the city said the offer is for you to plead guilty to the original charge or to proceed to trial unless you have a valid license now.
No, I surrendered my license due to the fact of my diabetes.
I don't know what he's talking about. We're not talking about any violations. We're talking about your license, sir.
I understand that. I surrendered my driver's license due to the fact of my diabetes.
Oh, okay. So you are no longer seeking to get a valid license. So as to the original charge, are you seeking to enter a guilty plea or do you want to proceed to trial?
Let's say this is just go with a guilty plea.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Hey, counsel, let me get your appearance for the record, please.
Catherine Nichols Lineker for the city, Your Honor.
Okay, Mr. Edwards, you have the following rights you'd have to give up if you wanted to plead guilty. First is your right to the presumption of innocence, so you're innocent until proven guilty, and you have the right to require the city prove your guilt by proving each element of the charge that's being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and not have that silence be used against you. You can waive your silence and testify at your trial if you'd like, and you have the right to subpoena witnesses to testify on your behalf. Do you understand all of those rights that you have to give up if you want to plead guilty?
Yes, ma'am.
Okay. Anyone threatening you to get you to plead guilty?
No, ma'am.
Any promises being extended to you if you plead guilty to this charge?
No, ma'am.
Okay. As to the failure to display a valid operator's license, how do you plead?
I plead guilty, ma'am. The
On or
reason why I
about
could not
January?
be-
Yep.
Pardon me?
You can say what you wanted to say.
The reason why I could not provide a driver's license was due to the fact me and my wife was involved in an argument. I left to resolve the argument, so it wouldn't get no heater and no further involvement. Or return to a violent domestic violence or whatever. I left the scene.
Okay, did you have a valid license at the time?
Yes, I did. She took my wallet. To this day, she still won't get give it back to me.
Okay,
So
but
I
sir, was
went-
this, let me stop you, because I gotta get certain pieces of information. Was this on January 31st, 2024?
Yes,
And this was at Chilson Ave, at or near 7th Ave?
yes, I took the vehicle from the house to my shop where I work at. Just to avoid the conflict.
Okay, but you're saying your license was valid?
Yes,
Okay, do you see that, or do I can send her to get his driving record?
I have the driving record. I'm just trying to. This is on 13124. We have that there was a failure to comply posted on April 4, 2024. And that was suspected.
This should have been prior to that, though. So his license could have been valid at the time.
So yes, and I believe it was for a fail to display.
Yeah, if it was valid, that changes even the sentence. That's why I have to ask him that. But I don't know if your office knew that. He had a valid license at the time. All you have to do is bring it up here and show it, and it would have been $25. Okay, let's see. So
Indicates posted on December 16, 2024, there was a controlled substance crime, the violation due to May 22, 24.
correct, but this was January, this incident would have been prior to that,
Oh, January 24.
January 24. Okay. Well, okay, I accept your plea. I find your plea to be freely, voluntarily, and intelligently made. I have no reason to believe that you did have a valid license at that time. And so, with that being said, your fine is $25. You're being held on a probation.
I've been in jail been here about 3 weeks now, yes. I'm waiting to go to ICAP, ma'am.
Okay, well, I don't know who's holding you. I don't know where your probation violation is, but hopefully if that's something that works with your violation, they'll get that for you.
Okay.
It's not us. All right, you're all set for today.
Thank you again. Have a nice day.
Same to you. I'm gonna waive and close the file. Here's that. Okay, we're ready. No. Mrs. Zuniga's here, but where did the attorney go? Everybody else is here, but I thought we were ready on Mr. Zuniga. What happened to Mr. Kaplan?
He's speaking to Ms. Reynolds.
I only went off the record for Zuniga because they wanted paperwork.
Am I done, ma'am?
Yes, sir, you're free to go.
All right, thank you. Have a good day.
Same to you. Let's see, is Johnny Davidson here? No Johnny Davidson, huh? Okay, well, Ms. Barney failed to appear. I'm dismissing the case.
I'm sorry?
He has failed to appear.
Okay, now how does this work?
I am dismissing his case. Did you file a counterclaim?
I did.
Okay, and did you want to, there's a default that will be entered against him for your counterclaim. So I'll dismiss his claim and grant your claim by default.
Sounds great to me. Thank you.
You need to, I don't know. I'll submit the default paperwork, and you'll get a copy of that in the mail, okay?
Yes, ma'am.
Thank you. You're free to go.
Okay. Well, I just received now. How does that work with the counters? So I'm not familiar with.
We are going to prepare the paperwork at the end of my docket. I will submit the default and sign it, and I will look at when I can get in the system what your counterclaim was for. It'll be granted by default. And then
Okay.
you can get a copy of that and then figure out how you'll get recovery on that by contacting the civil clerk for direction, okay?
Okay, so you don't need any of my actual documents or anything?
I do not, I'm not granting anything on the merits. That's when I would look at your paperwork and say you have a meritorious claim and I rule in your favor. He failed to appear, so I'm granting a default judgment.
Okay, thank you.
Okay, you're all set.
Yeah, have a great day.
Same to you. Okay, I'm back on the record in the matter of the city versus Zuniga. The parties, I believe, have you need, and are we ready to proceed?
That's ready, Your Honor.
Okay, we're still having a hearing, correct?
Correct, Your Honor.
Okay, you can call your witness.
The probation office.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? I do, Your Honor. Thank you. You can have a seat.
Your Honor, do you mind if I question from the seat as well?
I'm the one.
Okay, thank you.
Sorry.
Ms. Bayless, can you state and spell your name for the record, please?
Jody Bayless, J-O-D-I-E, Bayless, B-A-Y-L-I-S.
And how are you currently employed?
354 agents for probation.
And what do you do in the probation office?
I'm a probation officer.
Are you familiar with Jorge Zuniga?
I am.
How are you familiar with Jorge?
He's one of the probationers I supervise.
And do you know when Mr. Zuniga was sentenced to probation?
I think mid-October, early October.
And did you have the opportunity to review the terms of probation with Mr. Zuniga?
I did.
And did he indicate that he understood those terms?
He did.
Including the term of having a scram tether, is that correct?
That was added as a violation, but later, yes.
So you also reviewed the term of tether at the violation or at a different, after the violation, and it was added, correct?
Correct.
And I understand we're here on two separate violations, so just taking them one at a time. Did you become aware of an alleged violation in early February?
I did.
And can you tell us about that?
I received an update from JSP Monitoring. They're the company that monitors alcohol tether. I was notified that a violation was between approximately 3 dates, February 11th through 13th, including a tamper. There was additional, no, that was just it for the February 11th to 13th.
And what did you do next?
Reviewed the report and submitted a violation for the alcohol tamper for device.
And as to the second violation, did you become aware of another violation?
I did. Again, I received another tamper alert from JSP Monitoring. I was notified, well, I'm sorry, this one was prior. I was notified one of January 21st. Well, January 20th to the 22nd.
Was that the event date?
Yeah, that's when the event started and then when it ends.
Okay. And are you familiar with JSG?
I am using for
okay. And following the receipt of that information from JSG the first time, what did you do?
Again, reviewed the report and submitted a violation.
And Mr. Zuniga knew that he was on probation with you?
Correct.
And he acknowledged that he understood that he was not to use alcohol or non-prescribed drugs, is that correct?
That is correct.
And prior to today's hearing, has there been any prior violations for Mr. Zuniga?
We've had prior violations for positive tests.
Do you know how many technical violations he has up until today's date?
I'm going to say 3, yeah, so far at this point.
Okay. And any non-technicals up until today's date?
No.
Did you get the opportunity to speak directly with JSG?
I did regarding possible items Mr. Zumba thought were causing the tampers or positives.
Is there any other information that you would like to provide that may be helpful in understanding these violations further?
Only that at the beginning of his probation, additionally, Mr. Zumba did sign an alcohol exposure contract with me at his orders appointment that stated anywhere from cough syrups to non-alcoholic drinks, kombucha, any food and vegetable products was his responsibility of knowing what he consumed. And he did sign that, I believe that was October 28th or the end of October, so it would null any excuse for the positive, regardless of their alcohol or not.
Has Mr. Zunga been following his terms otherwise, to your knowledge?
Yes, he's fully compliant with his treatment.
More questions at this time, Your Honor?
Cross-exam.
Thank you. Your Honor. I just have a moment. Afternoon, Ms. Bayless. Do you know what is required for an event to qualify as a tamper event?
It would be something in between the device or something that's causing the device not to pick up readings on the defendant's ankle.
Okay. In any reading of a scram tether, there are 3 different readings, correct?
That is correct.
Okay. So do you know what would be required to be in those readings that would qualify it to be a tamper event?
Can you rephrase that question? I'm sorry.
Yes. Each one of those 3 readings, I believe one is called TAC, that's transdermal alcohol content, correct? And then there's, I forget, the electronic charge as well, correct? That reads the skin temperature.
That's correct.
And then there's the 3rd one, which I forget.
I'm not quite sure. I do have a witness here to testify to that goal. I don't know the complete logistics of it. But.
Okay. So you yourself can't testify to what caused the tamper?
As I wasn't with him, no. I
right. Okay.
State
well,
what was causing it.
But you can't, likewise, you can't read the report and determine from the report what the tamper event was, whether it was interference with the TAC level or interference with one of the other levels, correct?
Are you, sorry, I can't read the report or I can't determine what the tamper was?
I'm asking you if you're able to read the report and determine what it is that the tamper is based on.
No, that we wouldn't be able to tell what the tamper was.
Okay, sorry. My proficiency in these things is lacking as well, so it's hard sometimes to phrase the question properly. All right. At some point, my client was fitted with a tether, correct? Did you put the tether on him?
JSG does.
JSG, okay. Are you aware at some point whether he had the tether switched from one leg to another?
He did. He raised concerns and I suggested if it was bothering him at any point or he needed it switched, they could do that JSG monitoring.
Did you yourself look at the monitor at the time?
No, I didn't.
You know, the kind of things that can, I'm not talking about the readings on the report, I'm talking about the physical conditions that might cause it.
I mean, it could be a slew of things that would go on and on. We could stay here all day. There could be millions of things to call.
Nobody wants to sit here all day, but I can assure you of that. Would one of those things be a loose fitting tether?
I'm not sure on that.
You're not sure.
But I don't believe so.
Well, would you believe just whether you know it or don't know it? Okay.
I'm not sure.
Okay, thank you. Was he doing tests through your office as well?
We don't do testing in our office.
Okay, was he doing tests elsewhere that were being reported to you?
Abraham.
Okay, did he, since the previous violations that he's already been found guilty of, have there been any other positive reports for Beaver Health?
No, they've been negative.
Okay. Do you know about when those tests were given?
I believe he said, I think that twice a month random, your analysis, bulk analysis. I don't recall his last test we had there.
Okay. Do you remember if they were before or after these dates?
I cannot recall that.
No? Okay. That's all I have. Thank you.
Thank you.
Yes, Your Honor, I just wanted to confirm. As it relates to the violations alleged from February 3rd, do you recall those event dates?
From the violation, I have in front of me if I can look at that.
If that would refresh your memory.
I submitted violations, it's 2 pages, but the violation dates were for the following, but January 20th began the event that ended January 22nd. Additionally, it was on January 27th to February 1st.
And as it relates to the second violation on February 14th, or what allegation?
Those dates for those violations are February 11th to the 13th.
And that would be consistent with the report you received from JSG?
That is correct.
Our next witness.
Can we call Jonathan Hayes from JSG?
Mr. Hayes, can you raise your right hand? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can proceed.
Thank you, Your Honor. Mr. Hayes, if you would please state and spell your name for the record.
John Hayes, JOHNHAYS,
How are you currently employed, Mr. Hayes?
JSG Monitoring.
And what does JSG Monitoring do?
We provide electronic monitoring equipment to courts, sheriff's offices, and other companies nationwide.
And what is your position at JSG?
I am the president.
You can hear me okay, is that correct?
What was that? Yes, I can. Yes, sorry.
Okay, thank you. Are you familiar with Mr. Zinga's file at your company?
I am.
And do you know what date the defendant was sentenced to probation?
I do not. I know the date that he was placed on a scram device, but I'm not sure when he was sentenced to probation.
And what date was he placed on the scram?
January 17th of 2025.
And would it be standard procedure to ensure that that scram was placed on adequately to the ankle?
Yes.
And that would have been reviewed by one of your staff to ensure that that was receiving proper readings, correct?
Correct.
Thank you. So in this particular file, we've currently got 2 different violations, one authored on 2/3 and the other on 2/14. Are you familiar with those?
I am aware of 2 violations in court, and I did hear referenced a 3rd violation earlier. So yes.
Okay, thank you. If I may approach, I'm just gonna identify some information for you.
This is just coming from.
Where's the camera? Here, okay. All right, do you recognize this document right here?
I do.
Okay. Can you describe this document, please?
Yes, the document is what we report to the court when there's a confirmed tamper or a confirmed consumption event. The document that you're holding up is the document that we submit.
Okay. How about this page?
Yes,
Okay, and what is on this page?
that is page 2, which is a description of the technology as well as a data interpretation summary. In essence, it's a summary of what the document includes.
Okay. And this?
That is the confirmation criteria that we use to identify a confirmed tamper or obstruction event.
And this?
That is one of the violations in a graph format.
This?
That is the summary of the findings from the event.
Okay. I'm just gonna work off of this non-compliance report first. It's dated Thursday, January 23rd, 2025.
Okay.
Okay. Can you describe for us, please, how your monitoring technology works generally?
Yeah, so the Scram Cam device is a continuous alcohol monitor. The device is affixed to the ankle and monitors for alcohol consumption, tampering in the form of the device being removed, and tampering in the form of an obstruction being placed between the device and the client's leg. It takes a sample every 30 minutes of the insensible perspiration from the client to identify if alcohol is being detected, as well as the tamper technology that identifies if the device has been removed or if something's been placed between the device and the client's leg.
Okay. And are these types of reports kept in your ordinary course of business?
Yes.
And it would have been prepared contemporaneous to the violation event?
Correct.
And is the whole report a true and accurate representation?
Yes.
Of the event? Okay, thank you. I would move to admit this into evidence, Your Honor. We also have 2 more reports.
Marked.
And show counsel for final time so he can indicate the date. We're looking at the report date of June 23rd.
So there's 3 reports?
Yes. There's 2 violations. Okay. We're gonna move forward, if you would, with the report date of February 3rd. Do you recognize this report as well?
I do.
Okay. And is this report similar in substance to the other report that we've reviewed?
Correct.
Okay. So the same categories per page would be accurate for all of these pages I'm showing you. Is that correct?
That is correct.
Okay. It would be different as it relates to the specific event date.
Exactly right. It's a template that's used to report the violations. So the only thing different would be the dates.
Okay, thank you. to admit, I wish I was a little taller here, Mr. Hayes. But the third and final report is this guy with a report date of February 13. And these
Correct.
pages as well look familiar to you?
Yes.
And all of these would have been kept in the ordinary course of business
Yes.
and in contemporaneous with the tamper event date, correct?
Correct.
Okay. I think I missed a page, I'm sorry.
Yes.
Okay, thank you. All right. Council, have you had the opportunity to review those guys now?
Thank you.
Okay. So, Your Honor, I'd be moving to admit as plaintiff exhibit 1, a specific report date of January 23, 2025, plaintiffs 2 with a report date of February 3, 2025, and finally 3 with a report date of February 13, 2025.
Any objection? Admitted.
Thank you, Your Honor. Mr. Hayes, as it relates to the first report, can you walk the court through the report's findings, please?
Yes. So this violation is one that occurred on Monday, January 20th, beginning at 8:05 p.m. The obstruction, which is something placed between the device and the client's leg, remained there until Wednesday, January 22nd at 9:47 p.m. The duration of that tamper is 2 days, 1 hour, and 42 minutes. What that means is something was placed in between the device and the client's leg continuously for 2 days, 1 hour, and 42 minutes.
Are you familiar with what might cause a tamper like that?
Tamper like that, an obstruction would be the cause of something being placed between the device and the client's leg for that duration.
Is there any, is that like showering and things of that nature?
No, it would be something that is more reflective than the skin. I can tell you I've worn the device well over 100 times myself. I've tested pretty much every theory that I've ever heard for accidental tampering. I have never been able to recreate an event for the 3-hour or 8-hour minimum requirements, let alone in this case, 49 hours and 42 minutes.
And can you explain the graph located, please?
Yeah, so if you have the graph in front of you, do you have a color copy?
I do not, but I see a top and a bottom.
Okay, so there's 3 main lines on that graph. I'll explain it in terms that aren't color coordinated. The top line, or the line that is indicated by triangles, that is an ambient temperature. That is a combination of the environment and the client's body temperature. The line that is in the middle, or the line that is indicated by circles, that is the IR sensor. That's what we're using to identify that something has been placed in between the device and the client's leg. The line on the bottom, or as dictated by the squares, is the transdermal alcohol content. In this case, on this event, there was no alcohol detected. However, because the tamper's there, we can't identify whether alcohol was consumed during that time frame or not, which is in essence why it's a violation to tamper with the tether.
Right. So as a layman may understand it like myself, something was placed in between your technology, the monitor, and the leg that is abnormal enough to not read what the measures you are reading on the monitor. Is that correct?
That's correct. The best way to understand it is if you have a portable breathalyzer like what law enforcement uses, if they're taking a sample of their breath and the straws in their mouth, they could register a 0.020406. If you then take that straw out of their mouth, put 5 filters on it, or they take the test with the device 3 inches away from their mouth, we know that that reading is not going to be accurate because it's not getting an actual sample. When something's placed underneath the scram, we know it's not getting an accurate sample because the device isn't making contact with the skin, which is what's required.
And Can you review how you verify that your monitors are working as they are anticipated or as they are expected to?
Yes, so the device itself has a self-initiated test that is taken every 8 hours. It's a diagnostic test to identify if there's any issue with the device. The fuel cell, the IR sensor, the battery voltage, the strap, all the components. If at any point that test deems there's an issue with the device, the system will alert us immediately. We get the client in for an inspection. Additionally, something that we do when we get a confirmed tamper is we look at the time before and the time after. We try to see if the device appears to be loose because we do have technology that tells us if the device is too loose. In all of these cases, I've done that. There is nothing indicating there was any malfunction of the device. There's nothing indicating that there were issues with the device. Furthermore, the client's been on for, I believe, close to 90 days, and there were no issues on any days outside of these 3.
And you had the opportunity to review before and after the tamper dates, correct?
Correct.
Right. And you found that the monitor was operating correctly.
Correct.
Okay, if we can move on to the second report, please, and kind of walk through those same questions.
Yes, of course. So this event starts Monday, January 27th. It begins at 11:46 p.m. and remains there until Saturday, February 1st at 6:13 a.m. This event lasted 4 days, 6 hours, and 27 minutes. Additionally, during this violation, there were 2 readings of alcohol, 2 single readings of alcohol. However, for the same reason I explained earlier, we can't identify whether that was consumed alcohol or environmental alcohol.
Okay, and can you walk us through the graphs as it relates to this specific triggering event, please?
Yes, so again, what you're looking at is you're looking at the middle line that's indicated by circles. At the beginning of this, you'll see the date is January 28th at 12 a.m. And at the very end of this graph, you will see it's February 1st at 12 a.m. Again, 4 days, 6 hours, and 27 minutes. Something was placed underneath the device, between the device and the client's leg, and remained there that entire duration, never once returning to the baseline.
And you had the opportunity to review before and after the triggering event for any abnormalities in the device.
Correct.
And you found none?
Correct.
And then if we can move on to the third and final report, sir, please.
I have
You
it.
would describe that?
Yes, that event began Tuesday, February 11th at 10:12 a.m. and remained there until Thursday, February 13th at 12:22 a.m. This duration was 1 day, 14 hours, and 10 minutes, and there were 0 readings of alcohol during this time.
And is that similar as the other ones where there was an obstruction between the monitor and the leg?
Correct.
You had the opportunity to review the monitor before and after the triggering event to determine its functionality?
Yes.
And you found none?
Correct.
And you indicated that this particular defendant had already been on the scrim for about 90 days. Is that accurate?
Correct. As of today, January 17th, yes, it's, I believe, a week or so shy of, actually 2 months, I apologize.
Okay, thank you. Is there any other nuggets that you may be able to provide that would help explain this better to the court?
No, again, I've worn the device many times myself. It's referenced in peer-reviewed articles as very difficult to beat. However, the largest studies that have been done on it found 0 false positives in regards to confirmed consumption or confirmed tamper events. The cause of it, I can't tell you, but I can tell you it could not have accidentally happened.
How big were those studies? Do you recall?
I do not. I know the largest ones, the National Association of, or I'm sorry, Highway Transportation Safety Administration, NHTSA. That was a 76+ page article that was studying the SCRAM device specifically. There's multiple others, Colorado University, that all referenced exactly what I said.
I have nothing further.
Cross-examination.
Thank you.
Mr. Hayes, my client, you said, was put on tether on January 17th of this year, correct?
Correct.
And the first tamper event you recorded was on January 23rd of this year, correct?
The event actually was January 20th to the 22nd. I believe it was probably reported to the court on the 23rd.
Yes,
But yes.
Yeah. Okay. So it was not 2 months that he's gone without an event. It was only 6 days before there was a tamper event.
It was actually just a little over 2 days.
A little over 2 days. Okay. So at some point, my clients, well, let me ask you this. Do you personally handle my client's tether, or was it somebody else in your employee?
I did not install it. We have installers who do that.
Okay. At some point, do you know if my client's tether was removed and placed on his other leg?
Yes, on, I believe it was February 20th of this year, the client came into our office advising that he wanted it moved from one leg to the other.
Okay. Did you check the tether yourself?
I did not.
So you can't say yourself whether it was loose or not?
I cannot tell you physically that I saw it. I can review the data and make a good determination if it appeared to be loose, but I was not the one that moved it.
Okay. You're not qualified as a medical expert, of course, but you see people all the time in your work?
Yes, I'm not a medical expert, but I have been admitted as an expert on the SCRAM device in over 35 cases, district and circuit court levels.
That's not what I'm getting at. I was getting at you. Are you aware that, I guess it can be kind of common knowledge that people's ankles sometimes swell up and then shrink if they retain water?
Yes, it's actually one of the items covered in our participant agreement with the client.
Okay. Also, if somebody's working on their feet all day, it can cause their ankles to swell as well, right?
Yes.
So it could be a cause for a tether coming loose if it's fitted initially the time when their ankles are swollen, and then at some point later, they rest and that swelling alleviates, correct?
Somewhat correct.
Okay. And again, just to reiterate, you can't attest to whether the tether was loose or not in my client's case, because you didn't have it.
I can review the data and determine if the data shows it was loose, but I was not physically there, correct?
You talked earlier about the self-test that the tether is programmed to do, correct?
Correct.
How is that self-test tested itself to make sure that it's self-testing properly?
The details of it I'm not completely familiar with, but I know it tests for the voltage, the requirement of energy to pull a sample from the fuel cell, as well as the strap device case tampers that I explained earlier, but I'm not familiar with exactly what that looks like.
How often do you have the tethers maintained? Or let me ask this, how often do you have this specific tether maintained?
The devices are required to be calibrated every 365 worn days. The device in question was last calibrated August 27th of 2024 by SCRAM.
So since then, the only maintenance would be the self-test.
I apologize. We do maintenance in the office ourselves as far as replacing the strap, replacing the battery, the back plate, but the actual manufacturer does the calibration for the fuel cell and the internal components every 365 worn days.
That's all I have, Your Honor. Thank you.
You read the rest.
Mr. Kaplan was just asking about swollen ankles. Do you have a point of reference for what amount of swelling would actually be an obstruction? Like, I've been pregnant before and my ankles have been real big sometimes. So I'm just curious what that looks like, please.
So assuming that the ankle was swollen, and not just swollen, but considerably swollen at the time the device was placed on, and then somehow the ankle swelling went down, that would still require something to be placed between the device and the client's leg. The device has technology built in to tell us if it's loose. The line that I referenced earlier with the circles, the blue line, the middle line, if the device is too loose, that blue line goes down because it's taking a beam of light from the scram and it's flashing it to the skin and then measuring the reflectivity back. If it was too loose, that blue line goes down or the middle line goes down. If swelling was not high at the time of install and the client's leg swole up a considerable amount, it then pushes the skin closer to the scram, which does nothing to the reflectivity whatsoever. It's still the same skin tone. So the idea of a loose device could make it easier to tamper, but by no means would cause a tamper for 2 days, 1 hour, 4 days, 6 hours, and 1 day, 14 hours. It would still require client intervention to get something under it. And the more swollen the ankle is, I can tell you, the more difficult it is to accomplish that. It's very painful. Putting something under it, it hurts. So to remain there for such a long duration, it's just not possible.
And you had the opportunity to review data to determine whether or not it was loose, correct?
Yes.
Okay. And you found that that data did not reflect it being loose.
Correct.
I have nothing further. Thank you.
Thank you, Mr. Hayes.
Thank you, Your Honor.
Any other witnesses?
None, Your Honor.
Is the defense calling witnesses today?
No, Your Honor.
Argument.
Your Honor, throughout Mr. Hayes' testimony and Ms. Bayless's, it's clear that the city has reached its burden of proof in this matter as it relates to probation violations, indicating that defendant did have a tamper event with the scram. As we've indicated, there are 3 separate tampering events contained within the 2 violations. Ms. Bayless indicated that she had reviewed the conditions of probation with Mr. Zinga, and he acknowledged that he understood those conditions. She indicated specifically the form of essentially responsibility and awareness that you can't have anything of alcohol in your body while you are on probation. That was acknowledged by Mr. Zinga. Further, the testimony from Mr. Hayes indicates that the tether itself is a reliable piece of equipment, and it is backed in science with those 3 lines as the court was listening to and learning about. So, Your Honor, I believe it's clear that there were 3 separate tampering events that would make a violation of Mr. Zinga's probation. Specifically, the first tamper event of January 20 to the 22nd, the second tampering event from the 27th to, I believe, the 1st, and then the 3rd from the 11th of February to the 13th of February. It's quite clear that the city has met its burden, and we would ask you to find Mr. Zinga in violation of his probation. Thank you.
Counsel.
Your Honor, science is always absolute until further studies come out and prove that, well, maybe the science wasn't always as accurate as we thought it was and as effective as we thought it was. Maybe I'm editorializing a little bit, but I'm certain that the sun revolves around the earth because I see it go overhead, except we know that that's not the case because we've done research. I would love to tell you that we're absolutely certain, but the only thing we know is that there's something that shows that the tether is not picking up signals correctly, but they can't tell us what or why. There's not any evidence of alcohol in them, and Mr. Hayes says, well, it's not going to pick up alcohol because it's a tamper, except I don't know what I don't know. Nobody knows what they don't know. We know that we've got the science that tells us he tampered with it, but like I said, it's all, we can't say how it was tampered with, what tampered with it. We do know that it was switched from one leg to another because apparently there was a problem, but there's no evidence exactly what the problem is, except we do know that it had to be removed, put on another leg.
Well, I don't know that it had to be removed. The evidence is that he requested for it to be removed. Not that there was an issue that required it to be removed. He preferred it to be removed, and he went in and had it removed.
Well, and I guess there could have been more of an explanation there, and could have explored a little more as to why. It's a tether company. They always, I would imagine, they don't just follow our clients' orders. But
I can imagine they asked you which leg you want it on. It's your leg.
Well,
I don't think they care.
I understand. No, initially, sure, but to have it removed and put on another leg, I would, again, maybe I should have explored that further with him, but it seems fairly random that anybody could go in and say, hey, I want to send another leg, and they would question. In any event, Your Honor, the facts have been offered. We ask you to dismiss the charges.
Any argument?
No, Your Honor, I would stand by my initial statements. Thank you.
Okay, thank you. The court's heard testimony today, first from the defendant's probation officer, Ms. Bayless, and then from the president of JSG, who is the company that is employed for the use of their monitoring device. And we are before the court on two summons for violations. The first violation dates having alleged to have been between January 20th and 21st, 2025, and the other having been February 11th and 13th, 2025, and for extensive periods of time. And I've heard Mr. Hayes testify in more than one occasion. I've looked at some of the supporting reports in the past about how the technology works, the efficiency, the margin of error, and I recognize and can appreciate, Mr. Kaplan, that your argument about opposing the science. There's been nothing that's produced on this record to show me any opposition to the data that is not just used in this jurisdiction, but nationally, as it relates to the reliability of the scram tether and the functions thereof. There's also been no testimony that would support the notion that at the time that the tether was placed on your client's leg or ankle, that maybe at the time his ankle was swollen. There's been nothing to tell me that. And I can't surmise that. There's also been nothing to tell me that maybe that's why it had to be switched, but let's hypothesize and say maybe it was swollen at the time that the tether was placed on there. The testimony provided by Mr. Hayes would clarify that if his ankle was swollen when the device was affixed to the ankle, that once or if that swelling went down, there would be a reading that indicates to the JSG that it's loose. And it, of course, could make it easier to tamper, but that doesn't, it being loose doesn't create the tamper. And we're not talking about a short period of time. I think I've had people tell me that their sock got in between their tether before, something to that effect. We're talking about days are going by without there being any ability to get a reading. And I have reason to believe that your client was aware or should have been aware that if he's got something that's supposed to be testing his alcohol level on his leg, that if there was something in between there that he didn't put there, he should have known that there was something there. I don't believe that there was an accidental tether, and I don't believe that the information produced on this record supports that there was some accidental or incidental tamper, or that there was some kind of error or malfunction with this device. And your client's still wearing the same exact device. And since I arraigned him on the last one, not had an issue.
It was a loose. That's what they tell you.
But there's been no indication that it's been loose. Because
That's why I got it switched.
No. You had an opportunity. So I asked your client, I asked your attorney, was there going to be any witnesses on your behalf? And at that time, there was a no. And so when I'm speaking, it's not your opportunity to blur out on my record. Do you understand that?
Yes, ma'am.
Okay, I've already addressed the issue of it being loose. It doesn't match up with the science behind the device. The device triggers the company that it's loose. And if you knew that it was loose, it was your responsibility to notify JSG, if that's the reason why you had to switch in the first place, to have them tighten it up. But all of a sudden, it's not loose anymore and everything's fine. I'm going to confirm or sustain the violations for both I have 3 separate reports. There's one from the 20th confirmed dates, one from the 20th of January, February 11th, and then I don't know that I've ever arraigned him anything on the 27th.
I believe one violation contains 2 separate reports.
That must have been the first one.
Yes. February 3rd.
That's correct. I did arraign on those ones. And the January 27th. And so I am confirming those violations based on the testimony of the probation officer and the president of JSG. You can address the court before I impose sentencing.
The city would just ask for all the recommendations.
Absolutely for him.
I
The city-
understand.
They typically don't. The city typically does no fine, but
Never been good at silence. My apologies, guys.
No. Sorry, Your Honor. What's the recommendation?
the recommendation was to continue his probation, but to impose jail time. And I'm gonna remind your client that at the time that I put him on the tether, which was because he was refusing to test, that I held 7 days over his head.
And I saw that, Your Honor, in our notes here, but I wasn't sure if that was for a previous violation. I thought.
I held it in abeyance pending no further violations. This would be 3 more violations.
Gotcha. No, I understood that. It was the sequence of things that had me confused. Yeah, we would just ask that you'd already sentenced him to 7 days, obviously suspended.
I have not sentenced him anything yet. That was at the last hearing that I held for him in January, when I placed him on tether. I said that I would sentence him to 7 days, Ingham County Jail, held in abeyance. I'm continuing his probation. I add scram tether for 90 days.
Right, that's what I was trying to say. You'd sentenced him last time to the 7 days suspended. So we just asked that we follow that recommendation, as previously mentioned, continue probation. And the jail time is. You've already said.
He's set to end probation, I believe, on the 21st of July, and he'll continue his probation, but not until after he serves the 7 days that I promised him. So he's remanded to the Ingham County Jail for 7 days, and then he'll continue his probation. Any additional matters for the record?
It wasn't on my recommendation, but the continuation of the grandfather following.
That will continue.
Okay.
I'll write that in my note.
Thank you, Your Honor.
Thank you. I don't know that it's been 90 days anyway. Well, I guess it was almost right.
No, that's not. No.
Mr. Raleigh, did you have someone?
Mr. Hassan.
Mr. Hassan is ready to go. He knows what he wants to do now.
Yes.
Back on the record, the matter of the city of Lansing versus Fadul Hassan. Let's see, and this was the matter that they were amending the failure to display ops to an impeding traffic, and then he was going to have to accept responsibility to the plate violation. How did you want to proceed?
We will be accepting that.
That's what you want to do, sir? Okay, you sure this time?
Yes.
Okay, you're still employed at Amazon? Yes.
Yes.
Okay, so then you'll be able to make your payments, correct? The impeding is $135. When will you pay that? Sorry? On the 3rd. And then the late violation. The fine is $135 when you pay that. Next month. I'll give you 30 days to pay both, okay? You can pay at the criminal traffic window, or you can pay online using your case numbers, okay? But you're all set for today. You're welcome. Mr. Capper, you have another one?
I do, Your Honor. Desiree Reynolds.
City of Lansing versus Desiree Reynolds, 24-03543, appearance, please.
Catherine Nichols, for the city manager.
Under Jeffrey Kaplan, P74943, on behalf of the defendant who's appearing by Zoom.
Ms. Reynolds, please start your video.
I can't. It's saying that it's paused by you guys. The host has it paused. Okay. There we go.
Okay, thank you. Today was the date scheduled for a hearing for no ops. I think we adjourned this last month because she was getting an eye assessment. How are we proceeding?
Your Honor, my client is still in the process of trying to get her license. At this point, she needs paperwork from the Secretary of State with the date and time to do a driver assessment. So we'd ask for another adjournment so that you can take care of that, try to resolve this.
She's gotta get something from Secretary of State, so. That won't take them.
She did tell me she was in touch with them and they're supposed to be sending it out any day.
They said I should have it within the next couple weeks.
April 15th at what time?
9:30.
April 15th at 9:30.
Okay,
Thank you, Your Honor.
No problem. Do you have any questions, Ms. Reynolds?
no ma'am.
Any additional matters for the record, counsel?
Not for defense. Your Honor.
Thank you. You're all set.
Have a good day.
Thank you.
Your Honor, Brent Rivers,
Brett Rivers and what, this young man here? Your name's
Cody Wade.
Cody Wade. Did they determine if he had an attorney or not?
I do not.
Okay, how did you want to proceed? Are you trying to represent yourself or you want an attorney?
I want to represent myself.
You want what?
I want to represent myself.
Okay, well, then you have to speak with the prosecutor on this if you're gonna represent yourself. I see you got a plate in your hand. I don't know if you was trying to show her that.
Yes, I was.
Yes, Your Honor, the plate is from the dealer with the registration from the dealer as well. So we were prepared to move forward with a civil infraction. That's correct.
It's a civil infraction of what?
No proof of registration. Get the code for you.
Oh, no, I was trying to see why I had 2 files for him, and that's because he owes 185 on unknown insurance. When are you gonna pay that, sir?
I brought the dealership insurance also today.
Excuse me?
I said I brought the dealership insurance with me also.
He's like a 30, then
He didn't appear for the first date, it's probably what happened.
No, I was here, or I couldn't do it on Zoom, so I came in person.
No, your first, it looks like your explanation hearing was. It said February 24th, failed to appear. I'm not following. Why I said court date on the 24th, then court date on the 11th. Say you have proof of insurance?
Yeah.
You showed the city attorney? He showed you the city? I'm gonna set aside the default on that.
Oh. Let me just verify that this is within the ticket date. I believe it is.
Yeah, because it looks like he had a bench warrant, but then he must have appeared. And they gave him today's date for a pretrial, but they didn't set this aside. He must have been late, or probably that day.
He sat for a 48-hour hold. He failed to appear for arraignment. Yeah, he appeared late.
Same day he came and
Yeah.
It was the same day?
he did come, he came today. I don't know why they don't set it aside. And what is this one? Disobeyed sign? Was this all the same day? No, this one's old. This one's from 2022. Okay, on that one, you owe 186, sir. You're gonna pay that one.
If you can give me at least 30 days.
Okay, so the disobeyed sign from 2022. I'll note that you'll pay that within 30 days. The no insurance, I set aside in the dismissal and dismiss. And then drove unregistered, you said it was gonna be civil infraction of.
Your Honor, we would make the offer of no registration on person under
No registration.
257.223. I'm unaware if that's agreeable to Mr. Wade.
Okay, the fine is 135, sir. When are you gonna pay that? You need another 30 days for that one? I'll just, you'll pay that, the older one first, and then 30 days from that one, you'll pay this one, okay?
Okay.
You have any questions about how you make payment? Okay, you're all set, thank you. I'm sorry?
What's the?
All right.
Rivers, I think, is a failure to appear.
Right, Rivers failed to appear, no
Yes.
contact.
Right. The Sutter reached out to him, he never responded back.
Okay, I'll issue a bench warrant. And then I think that's the last letter, is that correct?
Yes, Your
I
Honor.
need a new date for the code compliance 30 days. April 15th at 11. April 15th at 11. For the code compliance hearing. Okay, I can't get into on base, so I don't know what they're anticipating I'm gonna do is, someone is in room 3 and needs help.
I told him I could email him if they need it, so he might be doing that.
Want me to do what?
That I can email him the joint pre-trial statement if they need it. I will email him.
Council Shovelbling, you were asking for help in the breakout room?
I just wanted to let the court know that we reached an agreement, and I wanted to know if you just wanted to let the court know.
Okay, you all have reached a resolution. Are you intending to file that with the court?
Yes, we'll prepare an agreed judgment entry for with Miss Oliver with the payment arrangement and send it over to her for signature and submit it to the court.
Okay, it's gonna be a consent judgment.
Yes.
Thank you, Ms. Oliver, that's correct?
That is correct.
Okay, you're all set for today. Thank you.
Thank you very much, Your Honor.
You're welcome. And let's see, I see Trevino.
Yeah. Yeah.
Okay, and counsel for TD Bank?
It's.
The counsel.
It says he has the case number and the name. But it says.
Who was that in the breakout room?
That's Blanchard from the Courtroom iPad. But
Discover Bank versus Trevino?
Yeah, but that one,
That's
that's
not right.
right. TD Bank though.
Right. Who put that name there?
I didn't.
This is not,
Did he?
they don't make any sense. It's not the
That's why
same
I'm
case.
confused.
William Shalom is supposed to be here for Discover Bank versus, and Mr. Blanchard was in person?
Yes.
Okay, let's find out. And who's Erica Burton here on?
Burton is,
Or what time is she?
she's my, last name is Serva. She said Burton, is her name. Serva is the last name.
Okay,
Her name.
anyone here for US Bank National?
Yes, Your Honor. Andrew Tetro for Plaintiff, U.S. Bank.
Okay, thank you. And then Counsel Williams, what matter are you here on?
Counsel Williams, but did you mean William Saloom?
Correct. Which matter are you here for? Because you have
Two cases, Your Honor.
Discover Bank versus okay, so you're here on the Trevino matter and you're here on behalf of TD Bank? Is that what you're saying?
Yes, I'm here for Discover Bank, Your Honor.
Got it. That was what the confusion was, because we see Discover Bank versus Rafael Trevino, but we have TD Bank versus Trevino. Got it. Okay. And then have you resolved the matter with Ms. Trevino?
Yes, I have. I think we need to place something on the record, but we have an agreement.
Okay, on the record in the matter of TD Bank versus Rafael Trevino, 24-03092, appearance, please.
Record William Saloom P41487, appearing on behalf of plaintiff TD Bank.
And then I see Rafaela Trevino is present. It looks like someone is assisting her. Ma'am, state your name, please.
My name?
No, are you Rafaela Trevino?
Yeah, I'm her, what do you call it?
No, I said, are you Rafaela Trevino?
No.
I am.
Okay.
I am.
Thank you. Thank you. Today was the date set for a hearing for motion for summary disposition. Counsel, you said you come to a resolution. You can put the terms on the record.
Thank you. Yes, we'll withdraw, of course. Position. Reached to a consent judgment in the amount of $2,771.09, and she would like to pay it on, and we receive payments on it of $100 fifth, with the by the 5th of the month until paid in full. Your Honor, we'll send her an agreement indicating the payment plan, but there is a judgment in the fund from the motion, which if I guess the parties would like the court to enter it, if it's acceptable to the court to enter it. That way I don't have to submit to her judgment and wait for her to get it back before I can get it to the court.
Okay, the unfortunate part is I can't get into my file to even see it. It's giving me an error, so I don't know what's in there. And you said there was a judgment that was submitted with the motion for summary. You just want me to edit it. It has all the same numbers on there, is what you're saying?
Yes, Your Honor, I'm sorry. I should have indicated. Should have the same numbers on it. And if the court just wants to check it as a consent, as opposed to being entered by summary disposition, would be fine. Just to save the step of resubmitting.
Sounds good. Ms. Trevino, is it accurate that you want to enter into a judgment by consent?
Yes.
Okay, no one's threatening you to do that?
No.
Okay, I will review and sign the paperwork, and counsel, if there does later become an issue, someone from the court will contact your office, okay?
Thank you very much. I appreciate that.
Thank you. You're all set, Ms. Trevino, unless you have questions for the court.
Thank you.
Thank you.
No problem. Discover Bank versus Thomas Blanchard, 24-07574.
Thank you, Your Honor. Again, for the record, William Sloan Perry on behalf of plaintiff Discover Bank.
Okay, this matter was scheduled for a pre-trial. You're Thomas Blanchard, sir?
Yes, ma'am, I am.
Okay, and Mr. Blanchard is present in person at the court. Let's see, you all came to a resolution, counsel, or did you do a joint pre-trial statement?
Yeah, I think we pre-trial statement. And I know that the defendant has indicated he has a debt consolidation company that he wishes to talk to our office to try to resolve the debt, which that's fine. I would ask him to have them contact us if he would, and see if we can work it out.
Actually, they did a year and a half ago, Your Honor.
Okay, so while you all are working through that, and I think I vaguely remember you mentioning that at your last court date, you all did complete the joint pre-trial statement, and counsel, you're going to file it?
Yes, we can file, Your Honor. Well, I don't know if we've completed it. Was that sent out to the parties as a? I'm not.
It was, I don't know that it was. I think the indication was if you needed the form, it could be emailed to you to complete a joint pre-trial statement.
I see. I mean, plaintiff doesn't require it. I don't know if defendant requires it.
No, it's the court that requires the joint pre-trial statement.
Yes, I see. Okay, so I guess we would need the form, Your Honor, to be, then we could.
Okay, I'm gonna reset this. And she's gonna email you the joint pre-trial statement, and you all can do that. I'm sure you all have exchanged contact information. Is that correct?
I have not. Well, they have my information, but the.
Were you just in the private meeting room with him?
I did not know, Your Honor.
I can give him.
I was. I apologize. I was, but I didn't exchange any information.
Oh, okay.
Your Honor, I believe I have his phone number. If it's 269 ending in 7367.
That's your phone number, sir?
No.
Oh,
okay. Here, write your phone number down on this, and we're gonna message it to the council, okay?
Thank you.
Thank you, Your Honor. And Mr. Blanchard, you'll find our phone number on the plea if you need to contact us.
Perfect.
Thank you. If you file your joint pre-trial statement before this next date, you don't need to appear. So I'm leaving it to you all to. You can message this to the attorney. I'm leaving it to you all to get together on your own time and get this completed or resolved. Once we get the joint trial statement, that's what makes us kick out your next court dates, which would include a trial date.
What is the date, Your Honor, that it needs to be filed by?
April 8th. April 8th. You have any questions today, sir?
So you've recessed this until?
Yeah, this is being recessed because you were put in a private meeting room and you should have been told to complete a joint pretrial statement, or you should have completed what, I don't know what happened, but it's 4 o'clock and I don't have a joint pretrial statement. So I'm gonna reset it.
Okay.
And I recognize, I believe this is your second time here?
Yes, ma'am.
Because I believe you said the last time that this was already taken care of under a debt consolidation.
That was my understanding.
Right, if you all want to talk about debt consolidation and whether or not this is resolved, you can do that outside of the court's time. But if I set it for a pretrial, the purpose is for you to complete a joint pretrial statement or to resolve the matter. And so that's why we're giving him your number so that you all can do one or the other before the 8th date, file the joint pretrial statement or resolution if that's what you come to. That could also include a dismissal if they determine it was settled under a debt consolidation, and then you won't have to appear. But if nothing is filed by the 8th, then you both need to appear. Okay?
Perfect.
Your Honor, I'm sure it will be filed. If for some reason we don't have cooperation from defendant in getting it, can we file it with the court, or do we have to appear on the 8th at that point?
Well, if he's not cooperating, I don't see how you can do a joint pretrial statement, because it's gotta be signed by him
That's what
or with his permission. Yep, so if I don't get a joint pretrial statement or a resolution signed by both parties, then you both have to appear.
On the 8th, at what time, Your Honor?
2:30.
Thank you, Your Honor.
Okay, you're all set for today.
Thank you.
Thank you. Andrew Tetro is here on which matter?
He is here on US Bank versus Erica Misurfa.
Oh, that's right, she's no longer, okay. Well, I don't know what kind of motion it was, because I don't know.
Unmute.
Garnishment and judgment.
Okay, you printed actually. Okay, on the record, in the matter of US Bank National, DBA Elon Financial Services versus Erica Burton, also known as Erica Misurva, 18-04202 GC, council appearance.
Good afternoon, Your Honor. Andrew Tetro for the plaintiff.
Okay, and then Ms. Burton is present via Zoom without counsel. I have a motion here that says, I am motioning to stop garnishment and appear before the court as I was never received any documentation regarding this case prior to January 2025, and I have never been associated with anything regarding US National Bank. Let's see here. Okay, counsel, you did get a copy of the motion.
Correct, Your Honor.
Okay, and it's really an objection to garnishment, but it's filed as a motion. Did you want to respond?
Just to say that plaintiff's position is that defendant hasn't raised a valid objection to the garnishment pursuant to MCR 3.101K, and that's all.
That is, okay. And ma'am, you received the garnishment. Let's see here. Counsel, can you make me aware of, just for my information, because I cannot get into my file. I see the request for garnishment and it's an address on Jennings. Is that the same address that was used to serve the complaint?
I don't believe so, Your Honor, but I'm going to pull up the documents and confirm it right now, if you can bear with me.
Okay.
I think at some point after the default judgment was entered, we discovered that there was a new address, but I'm trying to pull that up right now. I will say that my record does show that the summons and complaint were served personally on the defendant.
Okay. Okay, ma'am, you have filed a motion, but it's really called objection to a garnishment. And when you file for an objection to garnishment, the rules for the civil court procedure are very specific, and you have to assert one of those reasons as a valid claim as to why they can't garnish your wages or seek garnishment recovery on this. Your statement is that you never received documentation regarding this prior to January 2025, that is not a valid objection to the garnishment. So that's really what you're doing now, is attacking the judgment, and the court rule specifically states that you cannot attack a judgment through the garnishment.
Your Honor, I called the 48th district or 54A district court and was told by a court, I don't know if they're officers or what they are, that this is what I had to do, was file a motion to appear. That's what I was told by the courts to do. I have never heard of U.S. Bank National or anything, and I've never received anything personally to me, any documentation prior to January of 2025. I don't even know what this case is about.
I recognize what you're saying. However, what I'm telling you is that the court rule, Michigan Court Rule 3.101, K2, says objection shall be based on one or more of the following. So these are the valid ways that you can get an objection granted. You have to assert that the funds or the property are exempt from garnishment by law, that the garnishment is precluded by pendency of a bankruptcy proceeding, or that the garnishment is barred by an installation payment order that you've already been entered into, or that the garnishment is precluded because the maximum amount permitted by law is being withheld pursuant to a higher priority garnishment. So that would be like if you had another garnishment that had higher priority and the max amount of money is being garnished through that, or the judgment has been paid, or the garnishment was not properly issued or is otherwise invalid, or lastly, the balance on the statement sent pursuant to MCL 600.401258 is incorrect. So you've not asserted any of those things. What you're doing is attacking the validity of the judgment, meaning because you're saying you never heard of this, so there can't be a valid judgment, and that you can't do that under a garnishment order, is what the court rule says. You understand that?
What I'm not understanding, Your Honor, is when there was ever documentation given to me to appear to court for the garnishment to be ordered to begin with, I was told by the court to file a motion to appear to fight the garnishment. I was never told that I had to file an objection and what the objection should be. How would you like me to proceed? Because I've never heard of this. I don't have documentation to proceed to know how to file an objection because I've never heard of this case until now.
Okay, so what it sounds like is you got the it sounds like you got the garnishment, you called the clerk's office and they told you that your recourse would be to file an objection or a motion. And so that's what you did. But they're not attorneys, they're not supposed to advise you on what your recourse of action is, nor am I in a position to advise you of what you're supposed to do. You filed a motion. I have construed it as an objection because the motion doesn't really say what it is in the first place, other than that it's disputing the garnishment. You wanted to stop the garnishment. So that's what we call an objection to garnishment. And so that is controlled by the court rules. And the court rules gives me very specific ways in which I can grant your request to stop a garnishment, but you've not given me one of those ways, so I can't grant it.
So Your Honor, do I refile an actual objection and then proceed? No, I guess I'm sure what I'm supposed to do from now.
Can file. I have already construed your motion as an objection. So you refiling it as an objection, saying the same thing, will only get you right back where you are now, which is a denial of the objection, because I can't grant an objection because your reason is that you never received any documentation regarding this case. So the way the civil procedures work is there is a summons and complaint under the lawsuit that's filed. So you were sued and that they filed a proof of service. That's why I asked him what the address was that they served you at, that they filed a proof of service. He says that the proof of service is indicating that you were actually served in person. This is a 2018 case. I don't have access to the record to find out exactly when you were served, but that's information that the clerk's office could provide you. It says that you were served in person. The law gives you a time frame during that service for which you're to respond and appear in the lawsuit. And then it also allows you to proceed with a pretrial and demand a jury trial. but to litigate the case. I'm assuming there was a default judgment that was in this matter because you say you don't know anything about it. And so when that happens, if there's a default judgment, there's a time frame per the court rules that allows you to set aside a default judgment. You would file a motion to set aside the default. And then the court will have a hearing to address whether or not you have sufficiency to get that motion to set aside the default granted. Or you can, if there was an entry in other ways, you can find another way to appeal to get that reversed. What you're doing is attacking the garnishment. You cannot attack the judgment through the garnishment. The court rules are very specific as to that. And it says MCL 600.40125A may not be used to challenge the validity of the judgment previously entered. That's exactly what you're doing. You're challenging how valid the judgment against you is by attacking the garnishment. And you've not sufficiently pled a reason for me to grant your objection to the garnishment. So I cannot grant that for you, ma'am. Do you understand that?
How was I supposed to go through that whole process you just talked about, you know, filing before within those amount of days or whatever else? I never received the documentation.
I don't
So
have a
I
crystal
never
ball to give you
even
those
knew.
I can't give you those kind of answers. I recognize that your position is that you never received the paperwork or you were not aware that there was a lawsuit. They have paperwork to the contrary that says that you were served in person.
So do I get a copy of that paperwork? Because what was the address and the exact date that that documentation was supposedly given to me in person?
You can contact the clerk's office that told you to file this motion and to get a copy of whatever's in
They
the
would
file
not
from
give
the
me
clerk's
the
office.
information. I've already tried. They wouldn't give me the information.
You asked for a copy of the file and
Yes,
they didn't give it to you?
Yes, I did, because I don't have it because I never received it and they wouldn't give it to me.
You can always make a FOIA or a subpoena request to get a copy of a file. I don't know who told you that you couldn't get a copy of any proof of service that was filed unless it's beyond the retention record. And I don't believe that this is a case that would be beyond that. The other option is you can get a copy from Mr. Tetro, who's here on behalf of the plaintiff who's seeking the judgment against you. They can send you a copy of everything that they filed against you, including a copy of the proof of service. You can work with them to do that. But the court can't explain to you how you were supposed to respond to a lawsuit that you were named in. I can't tell you that. If you'd like, I can put you and Mr. Tetro in a private meeting room so you can exchange communication mediums and he can send you your request.
Please.
For the record, the motion or objection is denied. Counsel, can you provide the court with an order?
Yes, Your Honor. When we're done in the breakout room, are we good to just leave or do you want us to come back on the record?
Nope, you're free to go after you're done in the breakout room.
Okay, thank you, Judge.
You're welcome.